This is a community-supported legal education channel. Find out how you can support our mission at the links in the description below.
Hello everyone, I'm Leonard French, and I'm not your average attorney. Today I have for you a case out of the Supreme Court of Georgia. The justices uphold the right to resist an unlawful arrest. The court does a great job of summarizing everything, and it's a great read, so let's just jump into it. So here we are in the Supreme Court of Georgia. This was decided on October 5th, 2020, and this is Glenn versus the state. Justice Ellington is writing for us today. And the justice is right. We granted Christopher Glenn's petition for a writ of certiorari to consider whether the Court of Appeals erred in affirming the trial court's order revoking Glenn's probation based on its determination by a preponderance of the evidence that Glenn committed the felony offense of interference with government property by kicking and damaging the door of a police car when he was detained inside. In the lower court, Glenn, the Court of Appeals recited that only slight evidence is required to authorize revocation of probation. The court subsequently disapproved of this statement of the standard of proof. The standard for proving a probation violation is a preponderance of the evidence, not only slight evidence. Glenn's claim that he damaged the door in the course of exercising his common law right to resist an unlawful arrest and detention, which was rejected by the trial court and the Court of Appeals, raises two substantive questions: whether a person has a common law right to attempt to escape from the detention resulting from an unlawful arrest, and, if so, whether a person may damage government property in such an attempt. For the reasons explained below, we hold that the common law right to resist an unlawful arrest includes the right to use proportionate force against government property to escape an unlawful detention following the arrest. Because the trial court found that Glenn's arrest was unlawful, but did not then consider whether the force he used in attempting to escape the ensuing unlawful detention was proportionate, we vacate the Court of Appeals decision with direction that the case be remanded to the trial court to make this essential determination. The trial court conducted an evidentiary hearing to determine whether to revoke Glenn's probation for violating the conditions of a June 2017 probationary sentence by committing the new offense of loitering and prowling, obstruction of a law enforcement officer, and interference with government property. At the hearing, the state presented the testimony of 3 police officers and played about 4.5 minutes of video with audio that was recorded by one officer's body camera. That evidence showed the following. On May 3, 2018, an Athens-Clarke County police officer responded to a, quote, suspicious person call in the area of the Oglethorpe Elementary School shortly after students were dismissed at 2:30 p.m. The responding officer drove around the school property in his patrol car, and for a few seconds, he saw Glenn walking on the inside of a line of trees and shrubbery that bordered the road behind the school. The officer testified that he radioed to his dispatcher that he was getting out of his patrol car with a subject matching the description given by the initial 911 caller. The responding officer approached Glenn and called out to him, "Let me talk to you real quick." Glenn asked if he was being detained. The officer responded, "Yes," ordered Glenn to stop walking and to sit down, and radioed for backup. Glenn, who remained standing, asked the officer why he was being detained and said, "I'll tell you my name. It's Christopher Glenn. I'm walking home." The officer told Glenn that he was conducting an investigation and that if Glenn moved, he would be charged with obstruction, and if he tried to flee, the officer would use force if he had to. About 1 minute after the responding officer's initial contact with Glenn, another officer arrived. Each officer grasped one of Glenn's wrists, and they began to apply handcuffs. At the revocation hearing, the responding officer testified that when he and the second officer handcuffed Glenn, they were arresting him for loitering and prowling, although there was no evidence that any officer said so to Glenn, and for potential other charges for which the incident was still under investigation. He admitted that he and the other officers had not yet developed probable cause for any offense other than loitering and prowling. The second officer did not testify at the hearing. 2 more officers arrived in a 3rd patrol car and ran to join the others, followed soon thereafter by another officer in a 4th car. Glenn was handcuffed within 2 minutes of the responding officer's initial contact with him. While the first responding officer gripped Glenn's wrist and arm, the other officers searched his person and removed and inspected the contents of his pockets. After the search, the 2nd officer told Glenn he was going to have to take a seat in his patrol car. Glenn said, "I want you to tell me right here, what am I being detained for?" The 3rd officer told him, "For suspicion of a crime, a sexual assault crime against a minor." No other information about any alleged sexual assault complaint was put before the trial court. The responding officer testified that after Glenn had been detained and there were enough officers to maintain control, he left that location to continue his investigation of the suspicious person complaint at the school. The transcript of the probation revocation hearing reflects that the trial court reviewed only the first 4 minutes 34 seconds of the video, which was almost 44 minutes long. The video did not capture Glenn's resistance to being placed and detained in the patrol car. The 3rd officer testified that Glenn was placed in the 2nd officer's patrol car, and within minutes, the 2nd officer asked for an ambulance to evaluate Glenn, who had told him that he was dehydrated. An ambulance arrived and Glenn was placed in the treatment area of the ambulance. The supervising officer soon ordered that Glenn be removed from the ambulance because Glenn was in custody and his condition would be assessed by jail personnel. Instead of exiting, Glenn grabbed onto a seatbelt and the officers had to physically officers and hit the supervising officer's head with his own forehead, causing a small abrasion on the officer's cheek. The 3rd officer testified that Glenn became dead weight and resistant as officers took him into the patrol car and tried to put him in through the rear driver's side door. An officer reached in front of the passenger side and pulled Glenn into the car, the officer who had pulled him in and knocking the officer down. The officers then tried to put in from the other side of the car. Glenn kicked against the passenger side door hard enough to damage the hinges and propel himself out of the car. He stood up on the driver's side and the supervising officer knocked him to the ground. Officers put Glenn in the patrol car for the 3rd time. After the officers tied his legs and secured his feet to the floor, Glenn was taken to the jail. The day after Glenn was arrested, a probation officer requested and the trial court issued a warrant to arrest Glenn for violating the conditions of his probation by committing the new offenses of loitering and prowling, obstruction of a law enforcement officer, and interference with government property. A person commits the offense of loitering or prowling when he is in a place at a time or in a manner not usual for law-abiding individuals under circumstances that warrant a justifiable and reasonable alarm or immediate concern for the safety of persons or property in the vicinity. A person who knowingly and willfully obstructs or hinders any law enforcement officer in the lawful discharge of his or her official duties shall be guilty of a misdemeanor, and a person commits the offense of interference with government property when he destroys, damages, or defaces government property. 2 weeks later, the state filed a petition to revoke Glenn's probation, listing the same offenses as violations of his probation. After presentation of evidence at the hearing on the revocation petition, the state argued that the evidence showed that Glenn committed the offense of loitering and prowling by walking along the wooded edge of an elementary school as the school was being let out. The state argued that Glenn committed the offenses of obstruction and interference with government property by physically resisting in multiple ways at multiple points in time, while being detained pending further investigation of the reason for the officer's dispatch, resulting in property damage that rendered a police squad car vehicle unable to close properly. In addition, the state argued that even if the arrest was unlawful, such that Glenn did not commit the offense of obstruction, the unlawfulness of the arrest would not excuse his behavior in damaging government property. Glenn argued that the evidence instead showed that the responding officer lacked probable cause to arrest him for loitering and prowling, which made the whole arrest unlawful. He argued that under Georgia law, a person is allowed to resist an unlawful arrest with a reasonable amount of force, and that it does not matter whether the force used to get away from an illegal detention is directed at an officer or against an object. The trial court determined that the evidence did not support a finding by a preponderance of the evidence that Glenn had committed. The officers did not observe Glenn in a place at a time or in a manner not usual for law-abiding individuals, and found that there was no evidence of any circumstances of the type listed in the applicable statute as warranting alarm for the safety of persons or property in the vicinity. Among the circumstances which may be considered in determining whether alarm is warranted is the fact that the person takes flight upon the appearance of a law enforcement officer, refuses to identify himself, or manifestly endeavors to conceal himself or any object. The trial court noted that the officers involved failed to give Glenn, prior to arresting him, an opportunity to explain his presence and conduct so as to dispel any alarm or immediate concern which would otherwise be warranted. The trial court also determined that the evidence did not support a finding by the preponderance of the evidence that Glenn had committed the offense of obstruction because there had been no basis to arrest Glenn for loitering and prowling. But the trial court found, by a preponderance of the evidence, that Glenn had committed the felony offense of interference with government property by damaging the patrol car door. Specifically, the trial court found that even though Glenn's arrest for loitering and prowling was unlawful, he had no legal justification for damaging government property once he was in handcuffs and sitting in the patrol car. The trial court stated that damaging the car kind of goes outside the bounds. You'd have the right to come to court and attack the validity of the arrest or detainment or obstruction charges. The trial court granted the state's petition and revoked Glenn's probation for a period of 90 days. The trial court suspended the sentence conditioned on Glenn's appearance into the Treatment and Accountability Court Program. The Court of Appeals granted Glenn's application for a discretionary appeal and therefore affirmed the trial court's ruling by a split-panel decision. The majority noted that Glenn's argument was based in part on the right to use force against a police officer to resist an unlawful arrest, and also noted that there is a dearth of case law on whether the right extends to the use of force against property to counter an illegal arrest. Without resolving this question, the majority held that, given the lapse in time between when Glenn was placed into the patrol car and when he damaged the vehicle door, which the majority determined based on the responding officer's body camera to have been at least 15 minutes, Glenn's damage to the vehicle was not in response to an immediate need to resist an unlawful arrest, but rather was an intentional act occurring some time after he was detained. Then presiding Judge McFadden dissented, concluding that Glenn did indeed face an imminent threat in the form of immediate and continuing unlawful detention. The dissent reasoned that it could not be seriously argued that kidnapping victims must become compliant once they have been restrained and confined, and therefore justification would obviously preclude a charge of criminal damage to property against a kidnapping victim. Glenn argues that in Georgia, a person has a common law right to resist an unlawful arrest or detention with the degree of force necessary to achieve that purpose, that such resistance may include damaging government property in order to escape from an illegal detention, and that a detention following an unlawful arrest continues to be unlawful until such time as lawful process issues. The Georgia General Assembly adopted the common law of England as of May 14, 1776, as Georgia's own law, except to the extent that Georgia's statutory or constitutional law displaced the common law, and that adoption remains in force today. As explained below, with the adoption of the common law, including the law of arrests, Georgia incorporated an affirmative right that was embedded by 1776 in the common law of England to physically resist an unlawful arrest or escape from an unlawful detention. The common law of arrests. Personal liberty is destroyed, nor will we go upon him nor send upon him except by the lawful judgment of his peers or by the law of the land. Magna Carta section 39, 12-15. Common law criminal procedure was largely accusatory rather than investigatory in nature, and criminal proceedings were generally initiated by crime victims who went before a magistrate to obtain an arrest warrant. A complainant would appear before a judicial officer authorized to administer an oath, ordinarily a justice of the peace, swear under oath based on personal knowledge that a crime had been committed, and provide evidence showing that a certain person was known or reasonably suspected to be the offender. After considering the complainant's statement and any other evidence, the magistrate would issue a warrant directing that the offender be arrested and brought in to answer for the charge. When a warrant is received by the officer, he is bound to execute it so far as the jurisdiction of the magistrate and himself extends. Even when arrested pursuant to a warrant, the accused was to be brought to a justice of the peace who, after a hearing, would examine the accused without oath and the witness under oath, and either completely discharge the accused, set a reasonable bail for bailable offenses, or hold him in jail pending trial for non-bailable offenses. To protect public safety, warrantless arrests were permitted at common law for felonies, but warrantless arrests for misdemeanors and other petty offenses were only lawful where a peace officer personally witnessed the offense being committed and the misdemeanor amounted to a breach of the peace. Like other arrestees, a person arrested without a warrant would be taken to the justice of the peace to be discharged, bailed, or jailed. It follows that after a warrantless arrest, the accused could be lawfully detained after a judicial determination of sufficient grounds for the arrest. The common law right to resist an unlawful arrest or detention. The common law right to forcibly resist an unlawful arrest and detention arises in the context of was cited by John Adams in June 1769 in his argument and report to the Special Court of Admiralty in Boston. In Thule, a constable arrested without a warrant a woman who he suspected of being a disorderly person. 3 men, armed with swords, intervened and attempted to liberate the woman, before and again after the constable took her to and confined her in jail. Outside of the jail, one of the armed men fatally wounded a man who was helping to keep the woman in custody and to protect the constable. A jury found, among other facts, that the woman was not behaving. In fact, the court determined that the constable had no legal authority to arrest the woman and therefore was not executing the duties of his office, but was instead acting as a common oppressor. The court reasoned that an invasion of the liberty of any person was an offense against the Magna Carta and the laws in which all the subjects of England are concerned. Therefore, the court reasoned the imprisonment of a person without lawful authority, especially under a color of justice, is a sufficient provocation to all people out of compassion to use force to rescue a person who is unlawfully restrained of her liberty. The fact that the fatal blow was struck after the arrest of the woman was complete and she was confined in jail did not lessen the provocation caused by her unlawful detention. Certainly, the putting of her in prison, the court reasoned, and not carrying her before a justice, as they should have done, is an aggravation of the provocation arising from the illegal arrest. The court ruled that the provocation caused by the woman's unlawful arrest and her continued unlawful detention reduced the offense from murder to manslaughter. Homicide in resisting an arrest, which is substantially illegal, will at most amount only to manslaughter. As enunciated in Thule, the common law right to resist an unlawful arrest acted to mitigate the defendant's culpability for murder. However, when the rule was applied in cases where the defendant was charged with crimes other than in the course of resisting an unlawful arrest served as a complete defense to such. The constable arrested the defendant without a warrant, and the defendant attempted to escape and cut the face of a man who was helping the constable. The defendant was entitled to an acquittal on a charge of obstruction because the arrest was illegal. Where a man told a constable that the defendant, his employee, left the man's shop without finishing his work, and that the man suspected the defendant had taken the man's tools, the constable arrested the defendant without a warrant, and the defendant resisted the arrest by stabbing the constable with a knife. The defendant's assault was excused entirely because the arrest was illegal. Generally, under the common law, a person cannot be punished for fleeing from or physically resisting an unlawful arrest or escaping from an unlawful detention, so long as the person uses no more force than is necessary to achieve such a purpose. One has an undoubted right to resist an unlawful arrest, and courts will uphold the right of resistance in proper cases. If the officer had no right to arrest, the other party might resist the illegal attempt to arrest him, using no more force than was absolutely necessary to repel the assault constituting the attempt to arrest. A citizen, by common law and by Georgia law, can resist an illegal arrest, and in resistance of such arrest can use such force as may be necessary to prevent the same. Every man has a right to shun an illegal arrest by flight. The exercise of this right should not and would not subject him to be arrested as a fugitive. An officer cannot attempt an illegal arrest and then justify the attempt on the ground that the person sought to be arrested would not stand still until the arrest was made but ran away to avoid it. To call this endeavoring to escape and to treat it as legalizing what would otherwise be an illegal arrest would be going around in a circle. When an arrest is lawful, of course, the right to resist an unlawful arrest is not pertinent. Further, a person unlawfully arrested has a common law right to escape from detention following an unlawful arrest. Under common law, one who makes an illegal arrest has no right to detain the prisoner and no authority to prevent his escape. A person unlawfully arrested is justified in escaping if he can, and an attempt to rearrest him will be equally unlawful with the first arrest. The fact that no resistance or protest was made to the original arrest does not make it legal and deprive the person of the right to attempt to regain his liberty. Even if a suspect did, at first, agree to go with the officer to the police barracks, she had the right to withdraw her consent to do so where the arrest was unlawful. Thus, the common law right to resist an illegal detention continues after an unlawful warrantless arrest is accomplished. But as explained above, the right to resist an unlawful arrest or detention is not pertinent to arrests under warrants, and resistance to a detention after an arrest warrant is issued, or after judicial determination of sufficient grounds for arrest, would not be grounded in the common law right to resist an unlawful arrest. In the context of the common law right to resist an unlawful arrest, we have found no controlling authority for distinguishing between conduct that may harm an officer and conduct that may damage government property. When a person uses injurious force against an officer to resist being arrested, damage to government property, such as the officer's uniform being pierced by a bullet or blade, the officer's radio being damaged during a struggle with the arrestee, or even the officer's patrol car being damaged, are secondary concerns and less likely to result in separate criminal charges. Notwithstanding the dearth of case law on point, because the common law right to resist an unlawful arrest or detention is framed in terms of the proportionate use of force necessary to resist the force used to arrest or detain the person, we conclude that the right does not distinguish between the use of force against an arresting officer's person and the use of force against objects, including government property. Effect of Georgia's constitutional and statutory law on the common law right to resist an unlawful arrest or detention. Having determined that the common law of England circa May 1776 recognized a right to resist an unlawful arrest or detention, including the right to damage government property if necessary, as explained above, we must also determine whether that common law right has been modified or displaced by Georgia's constitutional or statutory law. First, we have found no authority in the Georgia Constitution that expressly restricts the right to use proportionate force necessary to resist an unlawful arrest or escape from an unlawful detention. The Georgia Constitution, in identical text to the Fourth Amendment to the United States Constitution, provides that the right of the people to be secure in their persons against unreasonable searches and seizures shall not be violated. Thus, an arrest, which is a seizure of one's person, must be reasonable. This provision of the Georgia Constitution did not displace the common law right by forbidding, expressly or by necessary implication, the extrajudicial remedy of using proportionate force to resist an unlawful arrest or escape from an unlawful detention. Nor have we found any statutory authority that places limitations on the common law right to resist an unlawful arrest or escape from an unlawful detention. The offense at issue in this case, interference with government property, was enacted in 1968. The common law right to resist an unlawful arrest or detention was a long-standing part of Georgia law by then, and the Code section does not expressly provide that it shall be no defense that the destruction, damage, or defacement of government property was incidental to the defendant's exercise of the common law right to resist an unlawful arrest or detention. Consequently, we see no basis for concluding that the Code section displaced this common law right. The Georgia statute that is perhaps most pertinent to the right to resist arrest is OCGA section 161024, defining the offense of obstruction. By its express terms, the law applies only when the defendant obstructs or hinders a law enforcement officer, quote, in the lawful discharge of his or her official duty. Law does not constitute the lawful discharge of the duties of a law enforcement officer, and therefore, one who resists an unlawful arrest or detention does not commit the offense of obstruction. In a case called Bacon v. State, a police officer is not discharging his lawful duties when he is making an unlawful arrest, and a person who resists an unlawful arrest does not hinder the officer in the lawful discharge of his official duties. A person has the right to resist an unlawful arrest. It follows that the law did not displace the common law right to resist an unlawful arrest. Similarly, under Georgia criminal law, a person commits the offense of escaping from custody or confinement prior to conviction only if the escape is from lawful custody or lawful confinement. This code section, therefore, does not affect the common law right to resist an unlawful detention by fleeing or escaping. Another criminal offense relevant to detentions and arrests is Section 16541A, which provides, quote, "A person commits the offense of false imprisonment when, in violation of the personal liberty of another, he arrests, confines, or detains such person without legal authority. A law enforcement officer who detains or arrests a person without legal authority may be guilty of the offense of false imprisonment. A victim of false imprisonment has the right to defend against the violation of his or her personal liberty." That law, therefore, did not displace the common law right to resist an unlawful detention or arrest. The Georgia General Assembly also recognized false imprisonment as a tort, which subjects the tortfeasor to liability for the victim's damages. Like the criminal offense, the tort of false imprisonment is framed in terms of an unlawful detention. But it is a defense to a civil claim for false imprisonment that the detention is by virtue of a warrant that is procured, issued, or executed by the defendant in good faith, which must be determined from the circumstances. In the case of an unlawful, warrantless arrest, as in this case, Georgia law is also consistent with the common law right to resist. Although the right to resist an unlawful arrest or detention is often considered a form of justification, Georgia's justification statutes, set out in Title 16, Chapter 3, Article 2, do not supplant the common law rule. Generally, quote, "The fact that a person's conduct is justified is a defense to prosecution for any crime based on that conduct. A person can claim the defense of justification, for example, against a charge based on acts performed in the course of making an arrest, but only in the case of a lawful arrest." In its several sections, Article 2 provides that the defense of justification can be claimed to protect a broad range of interests, such as protecting one's self or others from bodily harm, repelling another's unlawful intrusion into a habitation, avoiding criminal liability for conduct lawfully induced by a government officer or employee, fulfilling one's duties as a government officer or employee, and exercising the right to reasonably discipline one's child. The catch-all provision in Section 16.320, subsection 6, which provides that the defense of justification can be claimed in all other instances which stand upon the same footing of reason and justice as those enumerated in Article 2, shows that the specific provisions are not exclusive. To the extent a statutory defense of justification is at issue in this case, it is not self-defense under the law, but an unenumerated defense under the catch-all provision. Although the Code provides little guidance regarding when a defense stands upon the same footing of reason and justice as those enumerated in Article 2, in light of the broad range of interests protected in the enumerated justification defenses, we conclude that a jury could find that repelling an unlawful invasion of one's liberty with proportionate force causing damage to property does stand on such footing. Consequently, we see no basis for concluding that any code section in Article 2 displaced the common law right. Although many states have limited or eliminated the common law right to resist an unlawful arrest or detention, see Section 5 of the Uniform Arrest Act 1941, resisting arrest, if a person has reasonable ground to believe that he is being arrested by a peace officer, it is his duty to refrain from using force or any weapon in resisting arrest, regardless of whether or not there is a legal basis for the arrest. A version of Section 5 is in effect in at least 8 states: Alabama, California, Iowa, Kansas, Montana, New Hampshire, New York, and Oregon. At least 13 states have made it at least a misdemeanor to use force in resisting an arrest by a peace officer without limitation to resisting lawful arrests, although some require that the arrest be under color of the officer's official authority or words to that effect. Those laws are in Alaska, Arkansas, Colorado, Delaware, Kentucky, Hawaii, Massachusetts, Missouri, Nebraska, New Jersey, New Mexico, Rhode Island, and South Dakota. And the Model Penal Code of 1961 provides that the use of force is not justifiable to resist an arrest that the actor knows is being made by a peace officer, although the arrest is unlawful. A version of that law is in effect in at least 13 states: Arizona, Arkansas, Connecticut, Delaware, Florida, Maine, Montana, Nebraska, North Carolina, North Dakota, Pennsylvania, South Dakota, and Texas. Quote, the use of force to resist an arrest or search is justified, 1, if before the actor offers any resistance, the peace officer uses or attempts to use greater force than is necessary to make the arrest or search, and 2, when and to the degree the actor reasonably believes the force is immediately necessary to protect himself against the peace officer's use or attempted use of greater force than is necessary. It is no defense to prosecution for obstruction of a law enforcement officer that the arrest or search was unlawful. The fundamental interest in personal liberty is not recognized by the modern trend abrogating the right to resist unlawful arrest. Instead of continuing the common law tradition of favoring individual rights over state authority, contemporary law favors the statist values of order, process, and power, with little regard for whether such power of the states have completely eliminated the right to resist an unlawful arrest. The only exception seems to be if the officer is using more force than necessary, and only in certain states that have adopted the Model Penal Code of 1961. So don't take this as legal advice to just go start resisting unlawful arrest and then say that Leonard French told you to do so. I'm saying the opposite. That might be really unfair, but your only recourse is to convince your state congresses to change the law. After reviewing this state's, Georgia, constitutional and statutory provisions relevant to detentions and arrests, we conclude that the Georgia General Assembly has not done so and that the common law rule remains in effect in Georgia, at least with respect to charges of obstruction or interference with government property. And we conclude that the mere passage of time between an unlawful arrest and an attempt to escape from the ensuing detention has no bearing on whether the use of force was proportionate or necessary. Under Georgia law, therefore, a person may damage government property in an attempt to resist an unlawful warrantless arrest or escape an unlawful warrantless detention using no more than proportionate force, even where, as in this case, officers handcuff an arrestee and place him in a patrol car before the arrestee's property-damaging conduct. Glenn contends that he did not commit the felony offense of interference with government property because he damaged the patrol car only in the course of resisting the officer's use of force to unlawfully detain him and used no more than proportionate force, and therefore that the Court of Appeals erred in affirming the revocation of his probation. Quote, the appellate court will not interfere with a probation revocation unless there has been a manifest abuse of discretion on the part of the trial court. In terms of the sufficiency of the evidence, the appellate court will affirm the judgment of revocation if the record includes some competent evidence to show that the defendant violated the terms of his probation in the specific manner charged, notice of which must be provided in writing before the probation revocation hearing. However, the appellate court reviews questions of law de novo or brand new. Convictions for interference with government property where the defendant damaged a patrol car in the course of resisting an arrest have been affirmed on appeal in cases also affirming convictions of obstruction based on the same conduct. The holding that a conviction of obstruction was warranted in those cases means that the arrest in each case was lawful. So the property-damaging conduct, by definition, was not in the exercise of the right to resist an unlawful arrest. These cases therefore do not support a conviction for interference with government property in the course of resistance to an unlawful arrest. As recounted above, the trial court ruled that the state failed to establish by a preponderance of the evidence that Glenn's warrantless arrest for loitering and prowling was in the lawful discharge of the officer's official duties. The state did not seek review of the trial court's ruling that Glenn's warrantless arrest for loitering and prowling was unlawful. Therefore, we take that determination as a given and express no opinion whether that determination was correct. Because the officers were not in the lawful discharge of their duties when they handcuffed Glenn and forced him into the patrol car, he did not commit the offense of obstruction. Despite ruling that Glenn's arrest was unlawful, the trial court determined that Glenn committed the offense of interference with government property, reasoning that he damaged the patrol car outside the bounds of the period when he had any right to forcibly resist the arrest. That is, the trial court concluded that once Glenn was handcuffed and confined in a patrol car, he was obligated in court. After reviewing our state's constitutional and statutory provisions relevant to detentions and arrests, we concluded in Division 1 above that the common law right to resist an unlawful arrest or detention remains in effect in Georgia. Under the common law rule, Glenn's right to resist an unlawful detention did not evaporate simply because he kicked the car door some time after he was initially handcuffed and seated in the patrol car, but the trial court cut short its analysis when it failed to consider whether Glenn used force to resist the officer's actions that was proportionate under the circumstances. This determination is not for this court or for the Court of Appeals to make in the first instance. Accordingly, the judgment of the Court of Appeals is reversed, and the Court of Appeals is directed on remand to vacate the order revoking Glenn's probation and to remand this case to the trial court for further proceedings consistent with this opinion. Judgment reversed and case remanded with direction. All the justices concur except Warren, not participating. So there you go. What a remarkable opinion detailing the history of arrests and warrants and when it is legal to resist and when it is not. It turns out that you either need a warrant or a probable cause to arrest based on the law in order for it to be a lawful arrest, and at least in Georgia, you have the right to resist if those procedures are not followed and therefore the arrest is unlawful. Of course, you'll have to know in the middle of being arrested whether you're being arrested lawfully or not. So I wouldn't recommend resisting the officers. Keep your mouth shut, don't talk to the police, but probably don't resist even an unlawful arrest and rather have your day in court later. File something like a 42 USC 1983 civil rights action or something like that. You'll want to talk to your attorneys in your state to figure out what your rights are to resist an unlawful arrest, if you want to know. Otherwise, that's the law in Georgia. Thank you for joining me. I'm Leonard French, your favorite copyright attorney. I love you all, and I'll see you in the videos. Lawful Masses is a community-supported legal education channel here on YouTube, also on Floatplane and on Twitch. Thank you very much for your monthly support on patreon.com/ljfrench and sponsors.com/law. In the month of October, thank you to the $50 plus supporters Joe Tyson, Wes Delj, Citizen of the Sovereign, John Steele, Gavin Barnard, Eevi, Kyle Mudrak, Spirit Bear, Andy, Benjamin Hitov, Stephen, Goliath Cleric, Ugly Grill, Shielo T, Rudolph Bescherer Jr., Jay Dixon, HotGrillsInYourArea, Oscar the Phrophet, Brandyn Abel, Torpedan, IANAL, Cassandra, Curran, and ShadowTycho. And thank you to the $5 plus supporters who are scrolling on the screen in front of me. Everybody's on the LED panel behind me. I'll see you in the videos that drop. I love you all. Bye.